In this video, we're looking at employment tribunal appeals. My name's Alex Monaco, solicitor and owner of Monaco Solicitors. If you're watching this, you might want to appeal your employment tribunal decision. Within that, we're looking at the difference between reconsideration and appeal, what to put in an appeal, and whether or not it's worth doing. So, a reconsideration is different from an appeal. When an employment tribunal makes a decision, you will be allowed to ask them to reconsider that. That's fairly straightforward, relatively. It's done in writing, and you would present your written reasons why the tribunal should reconsider the decision, and you're looking for a significant error of law. So it's not about whether or not you agree with their decision, or whether they thought a witness was lying or not, or a specific fact that they decided on. It's more about whether they missed out a point of law, they perhaps didn't consider time limits properly, or didn't consider a procedural legal point. However, reconsideration is much less of an endeavour than an appeal, because a reconsideration is just done quickly by looking at the papers, the email that you've written, whereas an appeal is a proper hearing that will take place with proper bundles of documents. Won't necessarily have witnesses, but it will have legal argument from both sides. So an appeal is much more of an in-depth endeavour. What to put in your appeal? The first things first, before we look at how to write your appeal, is just make sure that you get your appeal issued in time. So you've got a certain amount of time. It's normally 42 days from the date of the judgment. Make sure it's issued in time. It's very, very strict. You won't be accepted if you issue your appeal out of time. And that means as well is to include all of the right documents. It's a very specific set of documents. You can read more on our website about that. The tribunal will send you also a list of what to include. You have to include everything exactly the way they asked. And again, they're very strict on appeals. So if you don't put in a certain document, your appeal won't be deemed to be effective, and it'll probably be out of time. Once you've got yourself a correctly formatted appeal within time, you need to look at what to write in there. And again, similar to reconsiderations, it is about an error of law. So it's not about whether you disagree with the tribunal on the facts. The judge will have said, well, we heard the witness A on this particular version of events, witness B with a slightly different version of events. As the tribunal, we preferred witness A, and these are the facts as we see them. You can't argue with that, sadly. What you can only argue with is whether the employment tribunal judge got the law wrong. So that's a very different situation than whether they got the facts wrong. So the facts you can't appeal, the law you can. So look at what law you want to appeal and put that in. Obviously, you're going to refer to any case law or any statutes that you're relying on. So the source of the law, and then compare that to what the judge actually applied and how they should have applied it differently. Thirdly, whether you should appeal your employment tribunal case at all. Well, frankly, it is very difficult to win employment tribunal appeals. By now, you've probably realised it's very difficult to win employment tribunal cases generally. Well, it's even more difficult to win an appeal. Judges often, they normally are quite professional. They do their job pretty well. So the fact that they will have made an error in law is deemed to be unlikely by other judges. They'll look at it much more carefully than they would look at your original case. So it's actually more difficult to win an appeal. It's certainly difficult to get right if you're arguing about complex points of law. That's not just saying what happened in the first place. So you see how it is more complex than your original claim. There might be less facts involved because it's more specific, but it's more complex. So obviously, I, being a lawyer, would probably say this, but it is something that you would want a lawyer to help you with, because it's about specific legal complexities, and it's about saying that a judge got the law wrong. So if you think about that, you're probably going to need a lawyer to help you to explain why a judge, who's a top lawyer, got the law wrong. That said, not everyone can afford lawyers, and not every lawyer will do cases on a no-win, no-fee basis. So, of course, if you're faced with this choice, go ahead and put the appeal in if you've got that willpower and you feel like you've got the energy to go ahead and just continue fighting your case. Wishing you the best of luck, and hopefully you can get justice at the end of your case. So if you're watching this video and you want to stay up to date, don't forget to subscribe to our channel on YouTube, and also it's worth having a look at our website as well to make sure that you've read up on all of your rights. Thank you very much for listening. I've been Alex Monaco, and it's been a real pleasure. Good luck with your case.